Criminal procedure is the topic that we will cover on the remaining videos of the substantive part of our session on criminal law and procedure. When we get to the hypos, we'll see that criminal law and procedure issues are blended together, as they often are on the real exam. So, we're in criminal procedure, and the first broad set of issues that we're going to deal with here, and actually 3/4 of the videos on this topic, are going to cover the exclusionary rule. As you may recall from our very first video in this series, criminal procedure breaks down into two broad categories, those that involve the exclusionary rule and those that do not. Exclusionary rule issues are generated by the 4th, 5th, and 6th amendments to the United States Constitution. And that's why I maintain that our work together on criminal procedure is really our first work on constitutional law. And that's why, if you're doing these seminars in the order that I recommend, you'll do constitutional law next, after you finish with criminal law and procedure. So, we begin with the 4th Amendment. The next two videos will cover the 5th and 6th Amendments. The 4th Amendment to the United States Constitution is part of the Bill of Rights, and the 4th Amendment is designed to protect against illegal searches and seizures. And the preferred remedy sought by defendants all over the country in criminal court is the exclusion of evidence based on a violation of the 4th Amendment. Broadly speaking, the 4th Amendment breaks down into two categories: the law of arrest and the law of searching and seizing evidence. So, the 4th Amendment is designed to protect against illegal searches and seizures, and the seizures that we're worried about here are the arrest of the person and the seizure of physical property, evidence of a crime. As we consider the 4th Amendment, the first issue that we always have to be aware of is standing. For a criminal defendant to be able to assert the 4th Amendment, that criminal defendant will have to show that his or her 4th Amendment rights have been violated as opposed to anybody else in the world. So, if the police violate the 4th Amendment rights of some friend of mine and come up with evidence that tends to show I am guilty, I don't get to use the 4th Amendment to try to prevent that evidence from being admitted, because I lack standing to complain about a constitutional violation of somebody else's rights. If the police or other law enforcement violate my rights, then I'm entitled to go for the 4th Amendment. But if I lack standing, I'm unable to bring the 4th Amendment to help me in my defense. So, next we turn to the law of arrest as it relates to the 4th Amendment. After that, we will turn to the law of the 4th Amendment and seizing other evidence. But with regard to arrest, the first thing that we can acknowledge right up front is that a police officer has to have probable cause to arrest somebody without a warrant. And also realize that, generally speaking, there is no warrant requirement for arresting somebody in public so long as the police have probable cause. But suppose we've got a situation where the police probably do have probable cause, but we've got a defendant who is at home. Under those circumstances, very generally speaking, law enforcement has to go to court and get a warrant, an arrest warrant, to go pick that person up. Generally speaking, remember, if the police have probable cause and the defendant is in public, the police can just go ahead and arrest that person. But if the suspect, instead of being in public, is just relaxing at home, unless there's some specific reason to go after that person beyond the probable cause, some danger to the community or other special circumstances, then law enforcement is supposed to go to a magistrate, get an arrest warrant, and then go arrest that person. Now, suppose we've got a situation where the defendant has been arrested unlawfully. Law enforcement has arrested somebody without a warrant and without probable cause. Any other evidence that is discovered right at that time is going to be excluded from evidence. Now, if they find the evidence first lawfully and then arrest somebody with probable cause, there's no problem. But if we stipulate for a moment that the arrest itself is invalid, then all of the evidence that will be obtained will be deemed illegal, and it will be excluded here as the basis of fruit of the poisonous tree. Basically, if the search begins unlawfully, all of the evidence that is found as a result of that unlawful search will be excluded. So, remember, if we've got probable cause, we can arrest in public with no problem. If we've got probable cause, but the defendant is at home and it isn't an emergency, then law enforcement has to go ahead and get a warrant. Remember also, two other ideas that are present here: stop and frisk. So long as there is reasonable suspicion, the officer may stop and frisk an individual, and that contact may lead to probable cause, but it does not require probable cause up front. Also, there's a fair amount of law dealing with the right to search an automobile without a warrant, the so-called automobile exception, and here the general rule is if law enforcement has probable cause to stop the driver, the car itself also can be subject to search, and that includes the wingspan, and it also probably includes the trunk as well. And this set of Fourth Amendment issues involving vehicles is subject to a fair amount of regular litigation in the appellate courts. This law is in a bit of flux. Also, you'll see from state to state that the law of search and seizure may vary somewhat by state also. Some states afford greater protection than the federal Constitution to suspects of crimes. Most states are testing national law with regard to criminal law and procedure, but not all. Check your state to make sure you're studying the right body of law. That basically wraps up the law of arrest. Now we turn to the search and seizure of physical evidence. Once again, realize that for somebody to have standing to contest this seizure of evidence, we've got to have government conduct, some sort of state action. If my next-door neighbor breaks into my house, finds evidence of a crime, and reports me to law enforcement, I don't get to rely on the Fourth Amendment because law enforcement did not violate my right to be secure in my home. My neighbor did. So we must have government conduct. Next, we've got to have a reasonable expectation of privacy. Obviously, I've got no expectation of privacy in my... Actually, I've got an expectation of privacy almost everywhere. What I was searching for was the following hypothetical. Suppose I leave my house, I get into my car, I drive to the local town, and I get out of my car and I go to have breakfast. And in the back seat of my car, I leave the bleeding remains of my victim, whom I have just knifed to death. Well, obviously, I've got no expectation of privacy if I've parked a car with a dead body in the back seat on a public street. Anybody can look in and see that dead body, and that would give any law enforcement official full probable cause to detain anybody reasonably connected with that car. So, we're dealing, generally speaking, in the Fourth Amendment issues with regard to the seizure of property with situations involving a search without a warrant. In a few minutes, we'll consider the issues of that can come up in criminal procedure when there is a search done with a warrant that ends up having some problems. But dealing with a search with a warrant, we know that a search warrant, or an arrest warrant for that matter, has to be issued by a neutral and detached magistrate, and there has to be a proffer by law enforcement that establishes their probable cause. Without that, the warrant won't be valid. Remember also that probable cause is a fairly nebulous idea, and in my view, most of the breaks go to the prosecution here with regard to probable cause. Probable cause will be established by the totality of the circumstances. There's no real black and white rule of where probable cause begins. The magistrate has to make a case-by-case decision. Also, at the time the warrant is issued, the warrant has to state with a reasonable degree of specificity what place will be searched and what evidence is being searched for. The more vague the contents of the warrant, the more vulnerable that warrant will be to attack. Now, the good faith of the law enforcement officers in executing a warrant will be taken into consideration when the defendant brings a defect of the warrant up as a justification for exclusion. And the case that actually gave rise to this so-called good faith exception was a case in which law enforcement failed to get the warrant stapled. The absence of a staple was being used by the defense to argue for exclusion of highly probative evidence of the defendant's guilt. And the court was unwilling to go that far. The court looked at this absence of a staple and said, nobody in this case is arguing that the warrant isn't true and that it isn't complete and that the pages that we're looking at are not the accurate, true, and complete search warrant. Therefore, the lack of a staple, although technically required, will not be enough to invalidate the search warrant. The good faith of the law enforcement officers who executed that search warrant will be enough to allow the government to get out of having to do without this evidence at trial. Now we turn to the issues of a search done without a warrant. And this is by far the more common set of facts that give rise to an essay question or to multi-state questions involving the Fourth Amendment. The first exception to a warrant requirement is where we have a search incident to a lawful arrest. This search has to be contemporaneous with the arrest and only within the area controlled by the defendant. So if we arrest a defendant outside a bar downtown, we don't get to go search his house immediately as a result of the arrest. But the immediate area controlled by the defendant, law enforcement is allowed to sue. Also, the automobile exception is the body of law that allows law enforcement to search a car without a warrant, pursuant typically to a lawful stop. The next exception to the warrant requirement is plain view. So if I've got my car parked on a public street with the bleeding dead body in the back seat in plain view, that is an observation that any law enforcement officer ought to be able to make and to testify to in court, despite the fact that there was no warrant issued in advance. A tricky issue dealing with the Fourth Amendment and the lack of a warrant is where the defendant consents to the search. Remember, crucially important, the suspect need not be informed of the right to deny consent. Now, one looks at that situation and acknowledges here law enforcement has got a huge advantage over a frightened and perhaps guilty suspect. But this is not a situation like Miranda, which we will touch on when we get to the Fifth Amendment. Law enforcement need not read a defendant his or her rights to be free from a search. If the defendant, the suspect, consents to a search, law enforcement is allowed to search without informing that suspect of his or her right to decline consent. Also, commonly tested is the issue where a roommate or some other third party consents to have law enforcement search some common area, and that consent is valid as well. No warrant will be required. But remember that a hotel manager is not allowed to give consent to search a hotel room that has already been leaded to the person staying in the hotel, because then the person who is resident in the hotel, the guest, has got a reasonable expectation of privacy. We've touched on stop and frisk briefly earlier. It's another exception to the warrant requirement, but there has to be reasonable suspicion of a crime, and we can only do a so-called pat-down search. Another very regularly tested little fact pattern is where we have roadblocks, and law enforcement is stopping people at a roadblock. It's okay to stop all cars at a fixed checkpoint. It's also okay to pick out an arbitrary sequence of vehicles, like, for example, every fourth vehicle for a stop. But anything more selective than that probably will be deemed a violation of the Fourth Amendment. Now remember that at the border, there is a much lower expectation of privacy, and the government has a much higher obligation to try to protect the health and safety and general welfare of the citizens. So at the border, law enforcement has got broad rights to search, and we are much more concerned about the Fifth Amendment due process issue than about the Fourth Amendment right to be free from unreasonable searches. If we have, for example, a border search that involves a very rough body cavity search performed by untrained, non-medical personnel, that might shock the conscience enough that we would use the Fifth Amendment to exclude the evidence, but it would not be a violation of the Fourth Amendment. And then, finally, with regard to wiretapping, typically there's a warrant requirement for a wiretap, but mere eavesdropping typically is not covered. So if I'm sitting at a table in a bar with a bunch of my criminal friends and I'm bragging about the crime spree that I've been involved with, some law enforcement officer can just sit at the table next to us, taking down careful notes of all of the various crimes that the suspect is confessing to, and all of that evidence will be admissible over a Fourth Amendment objection. So that concludes a very quick but fairly dense discussion of the Fourth Amendment as it relates to criminal procedure. Next, we will turn our attention to the Fifth Amendment.